Hi, hello, namaste, good morning, good afternoon, and good evening. I'm your RJ Sauji. I'm here on a very special, with a very special topic with our very own special guest. So let us invite her. So here we have today with us Janetha Reddy garu. So she will be clarifying all our doubts regarding visa stamping or GC like green card and everything. So with all our family and Telugu NRI Radio family members, we welcome you, Madam Janetha Reddy garu. So how are you, Madam?
Yeah, good. Thank you, Sowjanya garu. How are you?
Yeah, I'm too fine, Andy. So I
Thank
think
you
this
for
is the
having
very
me on the show.
perfect time to discuss with you regarding GC filing and I-140 or something like that, and also the visa renewals because nowadays everyone is facing lot of trouble with the visa renewals and everything due to this corona. We are not getting any appointments for the visa renewals, right?
Hmm.
Yeah. So yes. So yeah, madam, can you tell me what is the priority? Why the priority date is late nowadays? What is the reason behind the late?
Yeah, I think most of the, listeners know that, how the priority date works, and then, as per
Mm-hmm.
the monthly visa bulletin. So,
Mm-hmm.
last year, as everybody know, a lot of, whatever the immigrant visas that were supposed to be adjudicated because of USCIS delays, a lot of numbers, got wasted. And then again,
Right.
for the USCIS, the calendar year starts on October 1st and ends on September 30th. So,
Mm-hmm.
now again, as we are in the first quarter of first quarter of the visa numbers and all, so they are slowly allocating. And then, as everybody knows, last year in 2020,
Mm-hmm.
2020, most of the visas became available because of the pandemic. The reason is,
Yes.
a lot of consulates around were closed for adjudications, and then those unused numbers were kind of, they recapped, and, but however, it went waste. And we from our law firm itself, filed a lot of downgrades in
Mm-hmm.
2020, starting October. And
Right.
as per the September, in September, we got to know that, numbers are available starting October 1st of 2020. So, yeah, a lot of people, those who are trying to uh, get their I-140 petitions downgrade, they kind of did it,
Mm-hmm.
especially in October, November, and December months.
Right.
But however,
Right.
some of those EB3s got retrogressed again, and then, and now people started, kind of filing in EB2 again. If,
Mm-hmm.
again, the downgrade was not an amendment, if it is just a reclassification request that the employer did
Mm-hmm.
last year. So they again started and going for EB2s, because those dates are becoming current, for a lot of individuals. So,
Right.
we are seeing a lot of uptick in the EB2 filings again. However,
Mm-hmm.
they are still keeping both EB3 and EB2 as well, just to see,
Okay.
how things go out. Because again, now, because of the new variant, again, I think kind of chances are there, more numbers becoming available, but we never know. So,
Mm-hmm.
maybe, if somebody has a specific question related to these, we can go ahead and, take those questions.
Sure. Sure. Thank you. So, madam, today, someone has joined the call and they want to ask you some questions. Can
Mhm.
we take the calls?
Yes, yes.
Yes. Hi, hello,
Yeah,
namaste. Who is on the line?
yeah. Hi, my name is Venu. Uh,
Mm-hmm.
we uh, we applied 485 under EB3, but
Mm-hmm.
now dates were retrograded to 2012. So
Okay.
based on the I-140 approval and I-485, does my daughter age out is locked, or how the age out is works?
Usually how it works is, before they age out, that, 21 years. So the CSPA Act kind of, plays around and then, gets locked. But again, if they are over 21, then, they also kind of recapture the time frame for how long your I-140 is pending status. So, given the scenario, let's say if she's going to or just aged out, and then, you always will have the time to, recapture that particular, I-140 pending time frame. I think, that's the only way how it is working right now.
Okay, so there is no age lock, even though if we apply 485 and I-140 approved and dates are current, and now they are retrograded.
Yeah, if you already applied the 485 before she turned 21, yes, I would say that kind of benefits her, because before she turned 21, she already applied her 485, as long as the date was available for her. So that's going to benefit her.
Yeah, thank you.
You're welcome, Dana.
Yes. So, yeah. So, is anybody there on the line? Okay. So, yeah. So, Janetha, madam, so the thing is, what are the future plans for the priority date?
We exactly don't know how it's going to, because, every month, there are some predictions that automatically will be published in the bulletin. And then I think, the person who is in charge of the visa bulletin himself is kind of, doing some kind of YouTube channel these days, I think past year. So I think people can get some predictions in there. But yeah, I think now, given the scenario, how it is, EB3 is not really moving forward. It's just, there from the past, 2 months.
Okay.
At least EB2 is moving forward, but, a lot of people are really, frustrated. The reason is in anticipation of EB3 moving ahead. They thought that it's going to move, very rapidly. So that's the reason a lot of people downgraded. But a lot of people are disappointed that it's not moving as they interpreted it.
Right.
But you just have to, just play by the rules, and then, just have to go by the dates that are available. So I know I cannot predict those dates, because, it's all coming on the numbers. However, I guess, if we go back and then look into last year, the visa numbers were available, but however, the USCIS was not able to take the workload. So they kind of didn't open it. So I think as USCIS, guess, they have to hire more people, to honor these
Right.
number of filings, because we are seeing huge delays in the receipt notices as well, from the service centers. At least, people are waiting more than 6 weeks, in some cases 8 weeks, to have the receipt notices. And then it's very frustrating, because within that time frame, if the dates are going back and forth, people will get affected. So they really are, lagging behind. And if we see into 2020, October, November, and December time frames, they delayed, at least 5 to 6 months. There were some receipt notices they are issuing. USCIS is issuing 5-6 months into the filings. So this shows that, they are, heavily lack of staff in adjudicating the cases. I think people need to be, prepared on those lines, and then, make a kind of, decisions, very informed decision, talking to their own immigration attorney, what they have to do.
Right. Yeah. So, madam, I think we have got one more caller on the line. I will take the call. So, hi, hello, namaste. Who is on the line? Hello. Okay, I think they are on mute. I think. Okay. So, moving on to the next question. Madam, if the kids are like 21 years and above, and they are born in India, means they are not citizens of America. not only in India, from other countries also, if they're not born here, and also they lose their status. Okay, so what is the process for them?
See, I mean, till they are, 21, they kind of be dependent on their, parents' visa. But once they are 21, they can no longer be on the dependent visa. They had to, get their own independent status. So whatever it is, I mean, they had to go for their own independent status. Most of the time, these kids will go for, the F1 for status. Um, as you said that, um, how it's going to, I mean, play a role once they turn 21. So once they move on to the F1 status, I mean, they have that, the F1 status with them, and then, they will be moving forward with that one. But most of the people, those who are not 21, I mean, they of course will be benefited from this, the adjustment of status filings if the dates become current. So as I just said previously, if their the I-140 is pending for, let's say, one filed in a regular process, and then it took at least 6 or 8 months to get it adjudicated, that time will be recaptured at the time of filing. So they have to look into whether that will be fitting in their scenario. If not, of course, the kid will move on to a different status.
Okay.
But it all depends upon, I mean, but again, they have other scenarios, like, people moving forward with the F1 and then filing their own adjustment of status petitions later on once they have their employment-based visas and stuff like that.
Right. Yes. So now we got another caller. I will take the call. So hi, hello, namaste. Who is on the line?
Hi, my name is Manasa. I'm 20 years old. So I'm a H4 dependent child. So the primary applicant is my dad, and he has an approved I-140 under EB3. And when my dates were current in October, we applied for the 485. Mm-hmm. And then we got a receipt saying that they received it in October. And we also recently got the biometrics appointment. Mm-hmm. And after October, the dates got retrograded. So I was wondering if, based on my situation, whether my age will get locked or not, based on CSPA.
Oh, as per the CSPA, I mean, as I just mentioned, you had to look into the I-140 filing timeframes, whether, that will allow you to recapture those timeframes. But however, I mean, it's a good signal that, I mean, you were able to file as a derivative beneficiary under your father's, the AOS, and then you were able to have the biometrics. I think soon you will be getting your, EAD and advanced parole, no matter the dates got retrogressed. So, I would say, definitely keep an eye on, the dates, and then especially you had to get the time frame, how long your dad's I-140 petition was pending. So based on that, I mean, there might be some time frame that, can be recaptured later.
Okay. And you said that I have a high chance of getting the EAD, but my another question is, by the time I turn 21, if I don't get the EAD, what would happen?
See, if you don't get at some point of time, you had to get the EAD, because as you already filed, no matter the dates are retrogressed, we are seeing EAD and the advanced parole approvals. So what I would recommend is, just reach out to the local, congressperson's office. So the congressional intervention might benefit you. You have to let them know that, this is the scenario, and then you will be aging out soon, and then, let them know to adjudicate your, at least EAD and advanced parole. That might benefit you, at least having the combo card in place.
Okay.
If not the Congress person's office, maybe you can reach out to the senator's office as well. But I would say I would recommend going for the local Congress person's office first.
Okay, and let's say in the worst case scenario, I still don't get the EAD before my 21st birthday. Would there be a bridge visa or something like that?
I mean, I
That
really
allows me
don't
to stay?
recommend going on the bridge visa, but again, I think it's better to go on your, the study visa. But again, these both are contradicting in itself. Having the 485, the adjustment of status pending, and then, going for the non-immigrant, F1 visa. So the only recommendation I would do is, follow up with the congressperson's office. But again, as you said, in the worst case scenario, yes, you have to move on to your own individual status once you are 21.
Okay. And since I think you said that I should go into the student visa or study visa, right? So wouldn't that be contradicting my 485 application because
That's what I
it's
said.
a permanent
That's what
resident
I said.
application?
Yes, they both are conflicting with each other, but of course you will not have a choice, other than that. But you also reach out to the local school, where you are actually going to, and then talk to them and then see whether they will be allowing you on this. I mean, because adjustment of status pending itself is not a status. So, beside that, you have to individually have your status as you are on, I believe, on the H4 right now. So, though it is contradicting, I mean, I don't see any other bridge visa in between. Though you are planning to go into any other non-immigrant, it plays out in the same way as the F1 as well, because everything is a non-immigrant one.
Okay. And can I go from an H4 visa to an H1 visa to keep my status?
Yeah, if you are eligible, yes, I mean, if I'm guessing the rules on the H1B, the employer is willing to sponsor you, and then if your H1B gets picked up in the lottery, yes, you can definitely move on to that H1B, and then that will benefit you, a lot than going on the other non-immigrant.
Okay. But if I change to the H1B, I lose my place in the EAD process?
No, that is a parallel petition that will be going on. That's adjustment of status, a petition that is pending. So this is your actual status. Right now you are on H4, so you'll be coming back onto the H1. Then that petition, whatever the adjustment of status petition that is pending, it will still be parallelly moving on because you filed it before you turn 21.
Right. So even if I go to an H1 and I'm above 21, my H4 visa, like the EAD process, is still going to go on.
Can you repeat that again? Sorry.
So so now I'm on H4 and I'm under 21, right? And if I go on to my own status, which is H1, and I'm no longer under 21, is that going to affect my EAD process, or will let's say in a few years I get the green card, would I still be eligible for that?
It shouldn't get affected, once the dates become current, and then, I mean, as you already applied, so, now you might have filed based on the filing date. But, based on the final action dates, because usually as per the CSPA, your age gets logged only when the final action dates are, current. So, whatever the adjustment of status petition, that's pending, you keep on renewing your, EAD and advance parole on that front. And at the same time, you will be maintaining your, the given other the other H1B status that you are on.
Okay. All right. Yeah. Thank you.
Thank you so much. So yeah, Janetha garu. So Janetha garu, yeah. So some bills on country quota eliminations are pending in the Congress regarding the immigration, right? So what is the status, and will they pass in future?
I mean, it all depends upon. We have been witnessing, a lot of immigration bills getting introduced, and then um, failing to get
Mm.
approved in both the houses. So, I mean, let's keep our hopes high that one day it gets approved. But yeah, every time a lot of people are being disappointed the way
Right.
that these bills are treated. I mean, they want to make some changes. I mean, adding some, the amendments to those. But yeah, I mean, nobody can really, say when exactly these are going to be passed, because I mean, they have to have that majority voting and then should be passed in both the houses. So, I mean, a lot of people witnessed that, time again and again, I mean, these bills are, not being passed in both the floors.
Okay, okay, okay. So one more thing, see, like in America, many people are working on contract basis, and only some are working on a regular basis, right? So, like when they are working on contract basis and they apply for GC, every time they move from one company to another company or one client to another client, there will be effect on their GC process, right?
I mean, it depends how, their GC, their actual position that the employer sponsored was, crafted. So,
Okay,
of course, I mean, in the IT industry, especially, the people
right,
will be, you know, relocating from, one location to the other location because,
right.
based on, the job availabilities. So let's say, I mean, if you take some of the employers, I mean, it's not a contract base; they are full time. But again, if they are working through the consulting companies, I mean, through that employer vendor, and client model, yes, of
Mm-hmm.
course, they will be moving from location to location. So, I mean, the attorneys representing their
Hello.
corporation definitely know how to craft out these,
Mm-hmm.
advertisements and then the labors, because there will be a travel requirement for these kind of positions, because
Right.
the employee will be a roving employee, and then they'll definitely include that one. So it shouldn't really affect
Mm-hmm.
if they included the travel. But if not, and then maybe when they are moving from location to location, when the travel is not included, and then the headquarters change, that's when it gets affected. And then when people get promoted from their job that was sponsored for to a different position, yes, in
Right.
that scenario also, they had to redo the process based on the kind of position what it is.
Okay, okay, got it. Yeah. So now we got another caller on the line. So we'll take
Hi,
the
this
call.
is
Hi,
Raj.
hello. Yeah, yeah. Yeah,
Hi.
you can talk to Janetha, ma'am. Yeah.
Hi, ma'am. I have applied H4 EAD for my wife, and it's almost like 8 months. This is a renewal. There is
Mm-hmm.
no update other than the case has been received and it's in progress. We have received the
Mm-hmm.
last update in the month of August. It's been like more than 9 months.
Mm-hmm.
So, for the case update, do I need to approach any attorney or
Do
the
you
USC?
have the H4 in place already for her? The H4
Yeah,
approval?
yeah, H4 is in place right now.
Oh, okay. This is only for the EAD. Yeah, I mean, I would say
Yeah,
definitely reach out to the local, congressional office. Maybe their intervention might help you. But I guess we are still waiting on those kind of the. I mean, as you know that there was an agreement recently between the USCIS and for these H4 EADs and then L2 EADs. So only a few numbers that are qualified, like where they have the valid I-94, and then the EAD was applied 180 days before, but still waiting on for some of them to get implemented. But we are seeing there is a huge backlog on that front, and then even the intervention of the local Congress office is not really helping in any way, because the cases are backlogged pretty much.
Okay.
Okay. Yeah. Thank you, sir. Thank you for calling. And we have one more on the line. Hi, hello, namaste. Who is on the line? Hello.
Hi, this is Prem.
Okay. Hi. You can call to Janetha. Yeah.
Hi, Janetha. I had a question about pending adjustment of status application. So once my application was filed, once we are pending for more than 6 months with 485, do we need to do we need to be actively employed until the green card is approved, or we are allowed to have gaps in employment until USCIS acts on the application?
I don't think the gap is allowed, but of course, once you file the 485 and it's pending more than 180 days, you definitely can use the portability option and then move to some other employer. But however, every time you move to a different employer, you have to make two things clear on that. One is you are still continuing under the same or similar job option, and the second one is as soon as you join the other employer, or even before joining, send out the 485J under that AC21 portability. So that way you will be benefiting out of it. But of course, I don't think there is a gap in the employment is allowed. That will be questioned later on when you go for the 485 interview, because of course, if your employer sponsored you for this particular position, then they should have that availability. If not, you have to move forward with a different employer under the same or similar job title and duties.
But the 485 is for a future employment, right? After using portability, so they require the employment?
Yeah, of course, all the green cards are for the future employment, right? So let's say if you are with employer A right now and planning to move to B, so yes, you will be filing the 485J, the portability, as you are qualified because it's pending more than 180 days.
Okay. All right.
Okay, thank you.
So much.
Yeah. I think you got your doubt clarified?
Yeah.
Okay. Yes. Thank you so much for calling. Yes. So yeah, Janetha Garu, till when the priority date can move into 2022?
2022?
Mm-hmm. Because the priority date, everyone is expecting their priority date, right? So till when can what is the, can you estimate that date? When can the priority date can move in this year?
That's a tough question, because nobody knows, how the priority dates are moving. As I mentioned, in our earlier conversation, definitely there is a prediction in every visa bulletin, but we don't know on what basis. It's kind of the forward movement will happen. So they can follow the Department of State visa bulletin every month, and then just see those predictions. And also I'm seeing a new YouTube channel from the guy who is in charge of this visa bulletin, giving some of the dates, or how it kind of unfolds in the coming up bulletin.
Okay. So when can one individual can sponsor for GC to their family or relatives, and what is the process for this?
If a person is on a GC, he can sponsor his unmarried kids who are, below 21, and then the spouse as well. So, that's a different category. And then, if one is a US citizen, then, that becomes a different category. So as soon as they have the green card, if somebody is not married, then they can sponsor the spouse, which is also kind of, current in most of the scenarios in the past 2 years. Green card holder filing for the spouses, the dates are current on those lines, similar to the US citizen, how they will file for their spouse.
Okay. Why? Because one of my friends, like one of my neighbors, the parents are also already having GC, and but from many years, I think so, due to this pandemic, they did not visit US back, so they were stuck in India. Again, their visa stamping and everything got delayed due to the like this pandemic and everything. So even they are
Yeah,
touched if they
mhm.
tell me.
Yeah, if they already have a green card, see, as per, they had to follow those rules, like, not really staying 180 days outside the country. But of course,
Right.
Before 1 year, if they enter into the country on the green card, they would be good. But, at any point of time, if they, if they stay back in their home country more than a year, then they are kind of, jeopardizing the green card. So we heard during the pandemic, many of these cases where people kind of, not intentionally, as the flights were not there, and then, the vaccinations, and then, the pandemic problem, many people stayed back more than a year, and then, some of them tried to get the SB1 visa, returning resident visas, and, we are also hearing at the same time there are, denials in those kind of, returning SB1 visas. So it all depends upon. But of course, however, if the parents wants to, give up their green card, and then they want to come again on the, visitor visa, they could do so, definitely. But again, it all depends. I would say, especially, for parents, if they want to, go back and they are not really sure when they are going to come back, the best option for them would be doing a, the re-entry permit, which they can apply, and then, once they are done with the biometrics, they can leave the country. So that way their returning the re-entry permit would be mailed out to their home location, whatever they mentioned in the form. So that's what I would recommend, because especially how we are going back and forth in the past 2 years, like, most of the parents are not really comfortable traveling. So based on that, I would say
Okay. Yeah. Oh, hello.
yeah, I'm here.
Yeah. So, right. So, ma'am, can you explain? Can you tell us the details of visa interview waiver in India?
Can you say that?
Yeah. Can you
Hello?
tell us the hello? Can you tell us the details of visa
Yeah.
interview waiver in India?
Um, we kind of, got two notifications from, USCIS, how for the immigrants and non-immigrant visas that they are, waiving. So most of the people will be eligible for the drop boxes. As if somebody has, let's say, if a H1B going for visa again, and then they previously had a H1B, then they are waived. They kind of, fall into that waiver exemption, and they can go ahead and then, of course, they should have the appointment slots available, and then fill out the paperwork and all. But interview will be waived for them. But however, if the Department of State decides to go ahead and interview them, it's kind of, case by case basis scenario. And then one should really not have any visa denials previously. So based on
Okay.
that, I guess, that's how it works. But most of the um, um, uh, same category visas, they are eligible for the drop boxes.
Okay. Okay. Yes. So, what is the process for H4 EAD new renewals?
Um, it's if it is a renewal, I would say, definitely go ahead and then apply the 180 days before, so that way, at least you will have some kind of, hope that at least it will get approved. But however, though there was an agreement, basically, as I mentioned in the previous conversation,
Mm-hmm.
very few cases fit into that agreement. And then still we are seeing huge delays on that front. So,
Right.
but one should definitely make sure that they are applying if they have if they are filing for the renewals, file both H4 and EAD at the same time. And then if it is only EAD, then file 180 days before, because that's what one will be eligible to file for the EAD.
Okay. 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 Yeah. So, can you also explain us the updates regarding the EB3 and EB2? Because from EB3 again, many are upgrading. Like already you told, like upgrading to EB2, like that they're moving here and there. So, what are the updates regarding EB3 and EB2?
For a lot of people, those who filed the downgrades from EB2 to EB3 last year in 2020 October to December timeframe,
Mm-hmm.
most of them, got at least their, EADs and advanced paroles. And
Mm-hmm.
we saw the green card approvals as well, but those are only, before those whose priority date is before 2012. And there is no certain pattern on the USCIS how they are adjudicating these cases. Some of the cases, they are kind of, yeah, sending an interview notices. For some, they are waiving the interviews. Sometimes, if both husband and wife applied, they are giving for husband, the interview, and then wife's no interview notice. So we are seeing different patterns. But however, we are advising, clients, just to make sure that, when the interview notice comes, and then, we have one scenario where um, husband got the interview notice, but the wife did not. And when husband attended the interview, he kind of explained the whole scenario and all. And within the next week, the wife's got approved. So, saying that, each case definitely based on case to case basis. But if somebody is having on the adjustment of status application any of the kind of the citations or any arrest record, and those kind of things, we are seeing definitely those are being called for the interviews, and some of them are getting RFE'd, requesting for more documentation, and then the certified copies of the police reports, and then all of those things. So
Okay.
maybe if you are expecting your date moving forward in the next couple months, and then maybe you haven't gotten RFE, and if you have any of these underlying conditions, then definitely try to go ahead and then work on that paperwork and keep it ready, so that way once you have the RFE issued, you will not be wasting the time. But as we spoke, the initial time frame of the starting of this call, that most of the EB3's downgrades that they were filed were in retrogressed only. Very few people really got benefited out of that downgrading. But in
Okay.
actual, if the numbers wouldn't have gone waste, they would have
Mm-hmm.
definitely got benefited out of it. But very unfortunate scenario that
Right.
they had to, um, they kind of wasted the number, and then now they just had to wait and see how it goes.
Right. Right. So now, Janetha Garu, now Venkat Garu is online and he wants to ask you some questions. Yeah. So Venkat Garu, you can take over. Yeah.
Yeah. Thank you, Sowjanya. Yeah. Hi, Janetha Garu. Thank you for being with Telugu NRI Radio. So yeah, you're giving the excellent information. Hi, excellent information about aging out, and just I would like to touch some points, and I would like to discuss around GC adjustment of status and downgrade, EB upgrade, maybe EB3 to EB4, EB2, and the H1 LCA. The couple of questions. Maybe just you given information about downgrade and upgrade. So yes, all of them is downgraded to EB2, EB3, but unfortunately, some of people is benefited, but most of the people are still hanging in EB3. So EB2 is moving forward. What is the possibility to upgrade again? It means we are hearing about interfile. It means what is the technical term of interfile? Is there any form, or just we need to intimate to USCS, hey, I can eligible in both EB3 and EB2, just to have a look or something. Can you give me a brief additional information on this one?
Yeah, sure. How it works is, I mean, most of the time, when a person already has a 485 applied and then, pending under one category, and then, and if they are also eligible in the other category, definitely, the word interfiling, how it works is, the person, as soon as the priority dates are eligible, and then, the attorney will kind of, write a letter to the USCIS stating that, yes, they already had a pending 485, in a different category. So now they are also current in, EB2. So, just go ahead and then, interfile on the EB2, and then they should be receiving their card under the EB2 category. But however, saying that, they don't have the exact form, because, I guess in 2008, the USCIS had an email or a circulation on those lines, how they had to, file this. But again, it's been a very long time that, there was no exact, circulation or, things like that on those lines. We are not recommending interfiling. The reason is, definitely, yes, it kind of, might benefit on the fee front, but when looking into the time frames and all, it's not, because as it's not a form based and there is no fee collected for this one, so you had to keep writing to the USCIS on these lines, asking them. They might not even respond for the first time. When you go ahead and then, send them out a letter, maybe you had to issue them multiple, you had to write them multiple, letters before they adjudicate these particular things. So we as a law firm not really recommending to do an interfiling. The reason is, you have been waiting for your card to get approved for so long, and then when you want to really do an interfiling, it's kind of take time consuming, and at the same time there is no definite output and how long it's going to take. So people are going ahead filing another petitions under the EB2 category, as they are qualified for that, because that is the best case scenario. And then nobody wants to wait till these dates go back again, right? So that's why we are recommending definitely filing under the EB2 category again rather than filing, because the dynamics of it, how it works, are not really kind of pro to the applicants.
Okay. But in this scenario, did you see any conflict or something? What is the scenario? If you want to go to the EB2 file 485 adjustment status, do we need to withdraw existing
Sorry,
EB3?
Venkat, I lost you in between.
Oh, okay.
What did you
So
say? Sorry.
just you are saying that it recommended to file again in EB2, right? Who's those get the dates, priority dates. In this scenario, what are the steps? Is first we need to withdraw EB3, then we need to file EB2, or can we apply
No, I mean,
the parallel?
see, yeah, there is one trickier thing there. I mean, those who downgraded last year, I'm guessing most of them kind of requested a reclassification. But let's say if they amended from EB2 to EB3, then, I mean, for them, they cannot just go ahead and file under the EB2 again because they had to kind of, refile again under that category. But for those who just, I mean, from our law office, we just did a reclassification request for most of the people rather than, I mean, amending and all of those things. So, yes, they can keep both parallelly, like EB2 and EB3 parallelly. So as EB3 is already there, and then based on the current filing dates under the EB2 category, if they are eligible, they'll be going ahead and filing all the paperwork how similar to how they did in the EB3 category. So they will have both the petitions parallelly running, and then whichever dates move forward, that will be there. And then once they get the interview, that gets approved. And once, let's say, if EB2 gets approved, we are asking them to go ahead and then withdraw the EB3, which is pending adjudication. Sometimes we are hearing these days, past I think couple of weeks, that USCIS officers themselves are really looking into whether this person has both EB2 and EB3, whatever the EB2 dates they approve, and then they are kind of closing that EB3 case.
Okay. Did you see any filing case recently or anywhere?
Yes, recently, recently we saw one of the case, where technically under one category it got approved and the other category got closed just a couple of weeks ago.
Okay. So let's comes to EB3 I-140 downgrade. It means I think in regular processes we don't see any I-140 approved. So do you see any I-140 approved from your frame or something? I mean, just we don't have any
filed under the regular I-140 process.
Regular I-140 downgraded.
Not really. Most of them wanted to upgrade at some point. I mean, we upgraded them, and then some got RFEs, but I mean, no denial so far. So everything is getting approved. But those who filed, under the regular process, the I-140s, they are still pending adjudication. We haven't seen not even one single I-140 that was filed in the regular process got approved under the downgrade. So everything that was approved was.
Is there any different process for this? Yeah. Did you see any different process for downgrade I-140 and regular I-140?
Yes, I do, because I mean, regular I-140s, if you file under the normal process, anywhere between 6 to 8 months, they are getting approved. But unlike that one, these are kind of pending more than 12 months, 13, 14 months.
Yes, true. Okay. So, but is all downgraded in Texas Service Center, right? I mean, do you see any?
That's correct. That's correct. Yeah, we are seeing some straight approvals on those, but some of them, I would say at least 50-50. So 50% is getting approved without any RFEs once you premium. I mean, it was big challenging task as well initially to premium upgrade because there were no original labors that were available, right?
Center.
So USCIS, kept on sending back saying that, we don't have the original, we had to request it from the DOL. I think very few cases got accepted on a first attempt, but we kept on sending the cases, back again, giving, 3 to 4 weeks time frame to again premium upgrade. So it's kind of back and forth, but however, yes, I mean, they were successfully able to. I think after a while, there was a circulation to the USCIS folks in the service center, I guess, just to accept all the premium process. Sometimes, we used to see these petitions coming back and USCIS stating a cover letter saying, hey, mail it out after 30 days. So we did so. But bottom line is, yes, it was a time consuming process, but, all of these things, kind of unfolded because this is the very first time for the Indian nationals that, they had to, they downgraded to EB3 and then had to, go through all these scenarios. But the good side of it is, yes, though they are issuing the RFEs, we are seeing the approvals.
Okay, that's a good sign. Okay. So I have a question on H1 LCA. So one scenario is applied for renewal, H1 renewal. At the time, this in pandemic situation, most of the consultants working in both maybe work from home. So in this case, we need to provide the both address, the client location and the home address. So in this scenario, after apply the extension, the client location was changed. It changed to the another location, but the work from home addresses still exist in the labor. Let's say if the H1 applicant want to go to the visa stamping, right? So do we need to provide work from home address as a working location to visa officer, or just we need to what is it? We need to amendment client address again and go to the visa stamping?
Say it depends where exactly he's working. Let's say if the client is asking him to come back to the client location, definitely if it is not falling within the same MSA as the home location is located, that petition definitely needs to be amended. Excuse me.
That's true. Okay. But still is working from home, it can be.
Yeah, if he's still working from home, definitely as it is covered under the LCA, so, there is no need for amendment. Excuse me. There is no need for amendment, but at the same time, I would recommend taking a detailed client letter stating how this guy will be working from home.
Okay. It mentioned just provide with the detailed client letter with the work from home address that can be worked for the visa stamping, right?
That's correct.
Okay. So yeah. So just one question, it means is as a Manasa, the kid is turning out 21 years. I think thousands of kids have fallen into the same scenario. Is there any suggestion from you, from attorney perspective, to keep or maybe keep on eye some areas? Maybe they can look into that one and avoid aging out something. Is any suggestion on that one? That is a very sensitive area. It's a very is a very sensitive area because if in family one kid is on H4 and another kid is a citizen, it tied to sentimental after 21 years. So they grown here, they went to school here, and then after 21 years, all of it will change everything. It means it turning around, right? So as for it means, is there a suggestion to the parents so that their kid maybe utilize the GC so that they can build a future upon it?
Yeah, there are people, where we are seeing that, the principal applicant is qualified for the EB1 category. So, if they are eligible under that one, yes, parents can definitely, choose that route, like, requesting the employer if they are really, qualifying for that one. But if not, a lot of people, as we said, the scope in here is very less because, the aging out perspective, only once that final action dates are there, because right now many filings are being filed based on the filing date itself, because the filing date doesn't give them any protection at all. So only the final action dates kind of give them the protection. One thing is that they could recapture the time frame, how long their I-140 was pending when it was filed. They had to see that one as well. But I think this was heavily discussed during that 2020 October to December time frame. But again, I think the options are pretty limited for these kind of scenarios.
Okay. Yeah. So just about the visa bulletin, do you see any moving in EB3 or just hanging around? Just for your analysis. Just we know that it's very tough to.
Yeah, I think EB3 might
predict.
not really move much further. Maybe very limited time frame. But as guys are seeing that EB2 how it is moving, I think last month few months ago, like 6 months once and 8 months once, 7 months. So if the movement goes forward like this, that would be good. But maybe again because of the pandemic thing, if there are any unused numbers, maybe at the end of the fiscal year, hopefully, it might move forward a little bit.
Okay. Okay. Yeah. Yeah. I think I'm done, Janetha Garu. Yeah. Yeah. Thank you.
Okay.
Thank you very much for your time and clarifying immigration questions on Telugu NRI Radio platform. Thank you very much.
You're welcome.
So,
thanks for having me.
Yeah. Thank you. Yes,
Thank
Sowjanya,
you so much.
you can check out and conclude.
Yeah, thank you. So, Janetha garu, last one more question before winding up. So, like many know who all are can apply for GC, or like what are all the visa status people can apply for the GC, but still the newcomers, the new people who are applying for GC have some more doubts. So, I'm asking this. So, can you once again give a clarification of what type of visa holders can apply for GC? Like
what type
L1
of
or
visa
H4?
holders can apply GC?
Yeah. What is their
Of course,
qualification?
See, they have, several ways how they can, one is employment based, one is family based. When coming to employment based, of course, employer need to sponsor them. That position needs to be, there, and then, employer will sponsor for that particular position. That's the employment based scenario. And when coming back to the family based, yes, based on the green card, based on the citizenship. So, if you are a US citizen, of course, you can apply for your spouse, kids, brothers and sisters, parents, and all. If you are a green card holder, yes, unmarried kids and your spouse and all, but unfortunately not for the parents. So, two categories. One is employment based, one is the family based.
Okay. So also like one more thing, as you told now that we can apply for brothers and everyone. For example, my husband is applying GC for his parents. Can he apply for his brothers also?
If he is a US citizen, yes, he can.
Okay.
But of course, you have to keep one thing in mind. They fall under the last category, and then the wait time, especially for the Indian folks, who apply for their brothers and sisters, it's almost 14 to 15 years wait time.
Oh my God. Okay. Yes, got it. Thank you so much, Janetha garu. So patiently, you have clarified all the doubts. Thank you so much once again, because everyone is facing lot
You're
of problems regarding the GC or the EAD or anything, EB2, EB3. So thank you so much. You have really point to point, you have clarified all the doubts, and you are keenly, you have gone through all the scenarios and you explained everything. Thank you so much for giving us your valuable time. Thank you so much.
welcome,
Wish,
Lavanya, Sowjanya garu.
yeah, no worry. So wish to continue your a talk or discussion on these topics with you in future. Thank you so much once again. Telugu NRI Radio heartfully thank you sends the messages to you and thank you so much for everything we have done till now. Thank you so much, Annie. Have a nice day.
You're welcome. Likewise, you too. Thank you.
Thank you. Yes. So this is a special interview regarding GC, like green card and EAD and everything. So hopefully we'll talk on this topic in future. Thank you. Have a nice day, everyone. Signing